Good morning, friends. Hope that you all are doing well. We are aware that few years back we had two interesting judgments. One in the case of CA Goa by Honorable Bombay High Court, and another in the case of Chambal Fertilizers by Honorable Rajasthan High Court. In both these judgments, it was held that education cess is an allowable expenditure. Relying on these two judgments, quite a good number of assessees have claimed education cess as an allowable expenditure. Subsequently, White Finance Act, a retrospective amendment was made, and it was clarified that education cess is not an allowable expenditure. Now, the case which we are going to discuss in this video, what has happened in this case was, the assessees relying on these two judgments claimed education cess as an allowable expenditure. Meanwhile, the case of the assessee was taken up for a scrutiny. During the scrutiny assessment proceedings, when assessee was highlighted about this legal development and assessee being educated about the fact that the education cess is not an allowable expenditure on account of amendment being made by the Finance Act with a retrospective effect, the assessee withdrew that particular claim by specifically submitting a letter. Thereafter, assessment was completed and penalty proceedings were initiated on account of underreporting due to misreporting. So the 200% wala penalty proceedings was initiated and the penalty was levied as well. Assessee filed an appeal against this penalty proceedings. The Honorable CIT appeal was kind enough to grant a relief by converting this 200% wala penalty to 50% wala penalty, stating that it is a case of underreporting but not the case of underreporting on account of misreporting. The assessee now knocked the doors of the tribunal. The Honorable Income Tax Appellate Tribunal, Ahmedabad, has observed that it is a case where assessee has claimed this expenditure relying upon a settled legal position as was prevailing at that point of time, that education cess is an allowable expenditure. The assessee relied on two judgments. One is of the Bombay High Court, another was of the Rajasthan High Court. However, during the course of the assessment proceedings, the moment it was highlighted to the assessee that it is not an allowable expenditure, the assessee has withdrew the particular claim. Hence, assessee had no malafide intentions. The issue was debatable at a relevant point of time. Of course, department has come up with a mechanism under section 155(18) whereby a claim of education cess can be withdrawn, but by the time the mechanism was installed, the assessment in the case of assessee was completed, and during the course of assessment proceedings, assessee has withdrawn. So, assessee has clearly demonstrated its bona fides. And in those circumstances, the Honorable Ahmedabad ITAT, relying on the decision of Honorable Bombay High Court, held that it is not a case which either falls in underreporting or underreporting on account of misreporting. And consequently, the Honorable Ahmedabad ITAT has quashed the penalty. So certainly it's a decision which I believe would be useful to a lot of assessees. With this note, I take a leave of yours for today. We'll see you soon in the next video. Thank you very much.